PE, first off, I think starting off with fixed place PE, it defines it as fixed place PE means a place of business through which the business of an enterprise is wholly or partly carried on. And then subsequently, it gives down a list uh, of situations which would be included within this fixed place PE, which inter alia generally include place of management, a branch office, a factory, a workshop. At times, it could even include a mine or a gas well. So those are specific under the DTAAs, but typically a branch office, a project office, a factory is regarded as a fixed place P. Now, on the face of it, it seems like a very innocent definition, a simple definition, but it has its tests and how the judiciary has interpreted it in the past and of late. The complexities involved in analyzing a fixed place P have, I think, increased manifold. Um, so the first test is that you need to have here a fixed place of business. So there has to be a place of business which is at your disposal. You should have the right to control and manage that place in a manner that you are able to carry out business effectively while that place remains at your disposal. So the second requirement is being, carrying out a business activity or business from that place which you have at your disposal. The third requirement, which comes from the word fixed, is that there should be a certain degree of permanence, right? Now, each of these three tests are heavily factual. Now, what is a place of disposal or not at disposal has been a big issue. Permanence, there have been situations where uh, you know a taxpayer whose presence was less than 6 months has been not regarded as permanent. But if you all remember, in case of Formula One case, even 3 days was sufficient. So this was analyzed with regards to the specific nature of business or the kind of activity were you doing. Uh, a very recent example, I'll just take a minute to discuss this, is the 𝐼𝐼𝐿 case. To give you a very simplistic understanding of what the facts were, there were few hotels in India with which 𝐼𝐼𝐿 UAE entered into a service agreement whereby they would render certain strategic inputs and provide certain advice. Specifically, and how the Supreme Court noted is that under this agreement, they were, drafting their policies, HR policies, helping with hiring people. They had certain amount of control over these individuals as to who will do what. Uh, they were fixing the pricing, and all those kinds of services were being rendered under this agreement. Additionally, there was another Indian entity, 𝐼𝐼𝐿 affiliate, which was doing the day-to-day operation and management. When the Supreme Court looked into this, they interestingly thought that even though legally there is no control, or there is, these guys are not running, 𝐼𝐼𝐿 UAE is not running the business here. But if you see de facto, the amount of control they exercise on this entity is effectively resulting in 𝐼𝐼𝐿 establishing a place of business here in India through those hotels. Now, again, this is a very fact-specific exercise. They looked into n number of clauses within the agreement. They saw that the agreement was for a period of 20 years, which attributes certain amount of permanence. Uh, and they eventually decided that because of those agreements and the control they could exercise on their policy decisions, day-to-day administrative decisions, and even financial at times, uh, you would regard the Indian hotels as being a place of business at the disposal of 𝐼𝐼𝐿 UAE, from which it is carrying out its business, which is obviously the hoteling business. Uh, Various kinds of arguments were put forth by the department, by the taxpayer, saying that it is not looking into the day-to-day operations. It is only trying to uh, look into the activities which protects its brand, because at the end of the day, 𝐼𝐼𝐿 UAE is lending their brand to these guys. Uh, but nothing came through, and what the court highlighted, again, I mean, this decision to my mind, amongst other things, highlights the fact that PE analysis remains thoroughly factual. And what you may apply in one case may not technically apply in the other case, and it has to be seen on a case-to-case basis, because the scope of reading these terms uh, is very broad. Because while you may argue that even in the current decision, Supreme Court, they missed out something or they misread something, but unfortunately, how they've interpreted it is the law of the land now. Nobody can really do much about it. Um, you know, so the idea behind this entire discussion is that just because 𝐼𝐼𝐿 has discussed this in this particular manner, really doesn't mean it will apply equally to all cases exactly. You need to analyze it on a case-to-case basis, see where the substance lies, what the substance says and not merely go into the form. And that's exactly what the Supreme Court also did in this case. So that being one fixed place fee, the other would be a service fee, which requires you to be, which simply says that a taxpayer or a non-resident taxpayer would establish a service fee in India, for example, if it is rendering services through its employees in India for a specified period. Now, that period may be 90 days, 183 days, depends. Uh, the interesting thing to note here is it does not only talks about what services you render through employees, it also uses the term other persona. So it is not necessary that there has to be an employer-employee relationship which exists. Even if you exercise sufficient control, or um, you can, while you're disguising a particular arrangement, let's say as an independent contractor, but at the end of the day, that contractor is not working as an independent contractor and is more working like an employee, where there is certain economic dependence, where he's taking instructions on the matters from you, where you are liable for the work he's doing. There could be a number of tests which you look into practically. Even in those situations, you could end up creating a service fee, because all that you require is that you are in India rendering services for a stipulated period of time. Now, if you see all these things, they all imbibe a certain element of anti-avoidance, and they all promote substance over form. So that should remain, the basis of when you're analyzing PE risk and even reading DTAAs in general. Uh, the other thing which you should note here is, while we talk about days, it says say 90 days, you should not be in India rendering services more than 90 days or 183 days. Uh, there could be a situation where you have 100 people in India for 10 days. Now, do you think is that are you breaching the threshold? Is that a service fee? The courts have looked into it, and they have said what you need to consider while computing or looking into the thresholds of service fee is the solar days, not the man days. So you're not going to end up saying 100 people for 10 days. I have spent 1,000 days in India. No, it is still 10 days. You know, this does at times leave some arbitrage with non-residents to figure out their how people travel into, how their expats for travel into India, or they travel on the same dates. So why those kind of situations do arise, but that's the position which holds true as of today. You look into the solar days and not the man days. Service fee.